My fellow nationals, our parliament is currently comprised of 4 senators, one of whom is Attorney General Jason Hamilton. It is important to note that having 4 senators, one of whom is Attorney General, is completely legal under our Constitution. Today, however, the court ruled that procedurally, and I stress procedurally, Mr. Hamilton should have first been named a senator after one of the 2 senators' ministers would have resigned, and then be appointed Attorney General. My government aims at all times to adhere to the rules and guidelines of the Constitution. And so, following the court's ruling this morning, moved without delay to ensure that the process via which Mr. Hamilton was named Senator and Attorney General was corrected. Under our Constitution, the Federation of St. Kitts and Nevis must have an Attorney General. In order for Mr. Hamilton to properly serve in this capacity, therefore, he was earlier this afternoon named a senator in the National Assembly of St. Kitts and Nevis, the Honorable Nigel Carty having resigned as senator in order to make this possible. In response to the points raised in today's court ruling, Senator Hamilton was then appointed our nation's 5th post-independence Attorney General. This procedural requirement having been respected and in full compliance with the Constitution, the Honorable Nigel Carty will then be reappointed as a senator in the National Assembly of St. Kitts and Nevis, thereby making it possible for him to resume his responsibilities to the state in his capacity as Minister of Education and Information and Minister of Agriculture, Marine Resources and Cooperatives. Today's court ruling gave our government the opportunity to ensure full compliance with the procedural requirements of the court order. This we welcomed, and on this we have acted. We have decided to appeal the court's ruling based on the interpretation of Section 26(2) of the Constitution, which does not speak to a procedure. And given that there has been another interpretation of the section in the past, when there were the appointments of His Excellency Delano Bart QC and Dr. Dennis Merchant as senators and attorneys general. On the present court ruling, it has now been suggested that when Delano Bart resigned as senator and attorney general back in 2006, in order to have appointed Dr. Dennis Merchant as a senator and attorney general then, another senator minister would have had to resign at the same time in order to make the appointment. This was not done, and no one either inside or outside of government ever even hinted that such a maneuver was either required or necessary. As at this moment, we are still awaiting advice from the government legal team on the clarification from the court on the Senators' Increase of Number Act 2013, as earlier there appeared to have been some confusion on whether the judgment declared that the act is unconstitutional and or invalid as being in contradiction of sections 26 and 41 of our Constitution. We believe that this is a matter of immense public importance and must not be treated as trivial. We, however, would like to reiterate that the priority of my government at this time is the pursuance of the government's parliamentary agenda in support of the improved quality of life of the citizens of St. Kitts and Nevis and the consolidation of the principles of good governance on which our democracy is grounded. May God continue to bless and guide us all. I thank you.